This process was so important to our founding fathers in this country that they put it in the 7th Amendment, the right to trial by jury.
Copies of the what I believe to be the final verdict, final jury instructions and verdict forms. So let's confirm first that these are in fact the final verdict forms. Can counsel confirm that?
Yes, Your Honor. Plaintiff.
Or this is the final verdict form. Sorry, there's only one form in this case.
Yes, Your Honor.
And nobody has anything additional or any objection that they haven't raised to this that we haven't already discussed, correct?
No, plaintiff, Your Honor.
No, no.
No, Your Honor.
Okay, so let's go through the instructions and number them. I'm just gonna go through a number of these. Well, before I do that, does anybody have any additional instructions to propose?
Not for plaintiff, Your Honor.
No from defense.
No, Your Honor.
Okay, so let's go through them and number them. Ladies and gentlemen of the jury, it's now my duty as judge to instruct that's gonna be number 1, okay? If in these instructions, it's gonna be number 2. The purpose of the trial is ascertain the truth, that'll be 3. If during this trial, that'll be 4. The evidence which you are to consider, that'll be 5. You must decide all questions of fact in this case, that'll be 6. In determining whether any proposed instruction is approved, that would be 7. Credibility, believability of a witness, that'll be 8. Discrepancies in a witness's testimony, that'll be 9. We do have page numbers at the bottom left of these. Let me try to get that off. Okay, during the trial, you will receive deposition testimony. That'll be 10. Nothing negative should be inferred by the fact that the parties hired attorneys to pursue or defend their case. That'll be 11. No fixed standard exists. That'll be 12. A witness who has special knowledge, that'll be 13. An expert witness has testified, that'll be 14. A hypothetical question, that'll be 15. Whether any of these elements, that'll be 16. Although you are to consider, that'll be 17. The court has given you instructions, that'll be 18. You are admonished that no, that'll be 19. The masculine form, that'll be 20. If during your deliberations, that'll be 21. Before trial, that'll be 22. The lawyers and or witnesses, that'll be 23. The fact that a witness has been convicted of felony, that'll be 24. Plaintiff seeks to establish a claim of negligence, that'll be 25. Generally, everyone has a duty, that'll be 26. There was enforced a statute, that'll be 27. Plaintiff is seeking damages, that'll be 28. A legal cause of injury, that'll be 29. The preponderance of evidence, that'll be 30. The defendant claims the negligence of plaintiff's decedent, that'll be 31. Every person has the right to expect, that'll be 32. As used in these instructions, highway, that'll be 33. There was enforced at the time of the occurrence, that'll be 34. Defendant Zaon Collins pled guilty, that'll be 35. There was enforced at the time, that'll be 36. There was a law enforced at the time, that'll be 37. Clear and convincing evidence, that'll be 38. Plaintiffs Anna Echevarria, that'll be 39. Plaintiff Anna Echevarria, that'll be 40. You may not discuss or even consider, that'll be 41. The jury determines the plaintiff is entitled to recover, that'll be 42. Throughout the course of the trial, it may have been necessary for the parties or their counsel to step away, that'll be 43. It is your duty as jurors to consult, that'll be 44. When you retire, that'll be 45. And then finally, now you will listen to arguments, that'll be 46. Is plaintiff familiar with the court's with the court's proposed jury instructions numbers 1 through 46?
Yes, Your Honor.
Okay, does plaintiff object to giving any of those instructions?
No, Your Honor.
Okay, does the plaintiff have any additional instructions to propose?
No, Your Honor.
Okay, I'm gonna start first with Ms. Zinna. Is defendant Zaon familiar with the court's proposed jury instructions number 1 through 46?
Yes, Your Honor.
Okay, does the defendant have any additional instructions to propose?
No, Your Honor.
Okay, does the defendant object to giving any of those instructions?
Other than already stated, no additional objections.
Okay, and now with you, Mr. Johnson, is defendant Marvin Collins familiar with the court's proposed instructions numbers 1 through 46?
Yes, Your Honor.
Okay, does defendant Marvin Collins object to giving any of those instructions beyond what's already been discussed?
No, Your Honor.
Okay, does defendant Marvin Collins have any additional instructions to propose?
No, Your Honor.
Okay, do all counsel agree to the verdict forms that I gave everybody this morning, the verdict form, the special verdict form that I gave everybody this morning?
Yes, Your Honor.
Your Honor.
Yes, Your Honor.
Okay, so I think that covers everything. Does anybody else want to make any additional record at this time?
Judge, we just have these trade outs that we keep forgetting to do from Exhibit 7. We gave them
Well,
to defense
Are
last
are
week.
they agreed to?
Yes.
Yes.
Okay, do you just want to make a record of them? Did you guys already trade them out of the books or no?
We did not. I have
Okay.
4 copies.
Trade them out of the books while I'm copying the instructions, but go ahead and make your record. Thank you.
Yeah, thank you, Judge. The trade outs are from Exhibit 7, and it is, I believe, 5 pages. Base number 7108 through 7112. These are redacted per pretrial stipulation and agreed to by both sides. So we'll make those trade outs in the binders.
Okay, any additional record to make before we go off the record and you actually physically come up here and make those changes?
Nothing from plaintiff, Judge.
Nothing from defense.
No, Your Honor.
Okay, so we'll go off the record, make whatever changes to finalize the exhibits and anything else that's gonna go back there with them because what happens at the end, obviously, is my clerk just walks them back there and give me like about 10 minutes to copy all these. I'm gonna give each juror a copy of the jury instructions to follow because we have 46 of them. I think that's a lot to just make them sit here and listen to. Okay, no additional record before we go off the record, plaintiff's counsel.
I just want to ask you, when do you want to take a break? My closing is about 2 hours, and I know, I'm assuming reading the jury instructions is going to take about 45 minutes.
I can ask them, I can tell them that we have about 2 hours to go. And then there's gonna be a lunch break, and I can ask if anybody thinks that they are not gonna be able to last 2 hours after I read my part, if you want, because then we won't have a break in the middle of your closing.
It's up to you, Your Honor, of course. I'm fine taking a break in the middle of my closing if you want. Whatever is better for the court. I don't mind a break in the middle, if that makes sense.
Okay, I'll ask them what they prefer then.
Okay.
Okay, if they want to just power through. We are supposed to have lunch here at 11:30 for them. But I've asked that it not be something that needs to stay hot. So that if we're a little bit late, that they're not eating something that would taste way better if it had been 20 minutes earlier. Okay,
Good, thank you.
okay, so we'll go off the record right now and we'll come back on in about 15 minutes.
Thank you.
Thank you. If everyone could please be seated. We're back on the record in case A21844652C. Do counsel acknowledge the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Hey, welcome back, ladies and gentlemen. We are nearing the final stretch here. At this point in the trial, I'm about to instruct you upon the law that applies in this case. You should each have a copy of the instructions so you can follow along. You are not required to follow along, but you have the option to. That's why we give you your copy of the instructions too, because they can be lengthy. They can be kind of complicated, and sometimes it's just easier for people to read along as I read. So Here we go, ladies and gentlemen. Ladies and gentlemen of the jury, it is now my duty as the judge to instruct you in the law that applies in this case. It is your duty as the jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given to you in these instructions. Instruction number 2. If in these instructions, any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which these instructions are given has no significance as to their relative importance. Instruction number 3, the purpose of the trial is to ascertain the truth. Instruction number 4, if during this trial I have said or done anything which has suggested to you that I'm inclined to favor the claims or positions of any party, you will not be influenced by any such suggestion. I have not expressed nor intended to express, nor have I intended to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inference should or should not be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. Instruction number 5, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is the proof of one or more facts from which you could find another fact. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate, meaning to agree, to the existence of a fact, you must accept the stipulation of evidence and regard that fact as proved. Questions are not evidence. Only the answer is evidence. You should consider a question only if it helps you understand the witness's answer. Do not assume that something is true just because a question suggests that it is. You must also disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. If the court has instructed you that you must accept a fact as proven or draw a particular inference, you must do so. If the court has instructed you regarding a presumption regarding evidence, then you must consider that presumption as well. Instruction number 6. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law, or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. Instruction number 7. In determining whether any proposition has been proved, you should consider all the evidence bearing on the question without regard to which a party proved it. Instruction number 8. Credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. Instruction number 9, discrepancies in a witness's testimony or between his or her testimony and that of others, if there were any discrepancies, do not necessarily mean the witness should be discredited. Failure of recollection is a common experience. An innocent misrecollection is not uncommon. It is also a fact that 2 persons witnessing an incident or transaction often will see or hear it differently. Whether a discrepancy pertains to a fact of importance or only to a trivial detail should be considered in weighing its significance. Instruction number 10. During the trial, you received deposition testimony that was read from the deposition transcript and or shown by video. A deposition is the testimony of a person taken before trial. At a deposition, the person took the same oath to tell the truth that would be taken in court and is questioned by the attorneys. You must consider the deposition testimony that was presented to you in the same way as you consider testimony given in court. Instruction number 11. Nothing negative should be inferred by the fact that parties hired attorneys to pursue or defend their case. The right to retain counsel is a fundamental premise of our judicial system. Instruction number 12. No fixed standard exists for deciding the amount of physical and mental pain, suffering, or loss of enjoyment of life or damages. No fixed standard exists for deciding the amount of disfigurement. No fixed standard exists for deciding the amount of grief or sorrow or the loss of companionship, society, comfort, or consortum. Nor is the opinion of any witness required as to the amount of such reasonable compensation. You must use your judgment to decide upon a reasonable amount based on the evidence and your common sense. Instruction number 13. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his or her opinion as to any matter in which he or she is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. An expert witness has testified about his or her reliance upon books, treatises, articles, and statements that have not been admitted into evidence. Reference by the expert witness to this material is allowed so that the expert may tell you what he or she relied upon to form his or her opinions. You may not consider the material as evidence in this case. Rather, you may only consider the material to determine what weight, if any, you will give the expert's opinion. 15. A hypothetical question has been asked of an expert witness. In a hypothetical question, the expert witness is told to assume the truth of certain facts, and the expert witness is asked to give an opinion based upon those assumed facts. You must decide if all the facts assumed in the hypothetical question have been established by the evidence. You can decide the effect of that assumption upon the value of the opinion. Instruction number 16. Whether any of these elements of damages have been proven by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. However, absolute certainty as to the damage is not required. It is only required that plaintiff prove each item of damage by a preponderance of the evidence. Although you are to consider only the evidence in this case in reaching your verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number 18. The court has given you instructions embodying various rules of the law to help guide you to a just and lawful verdict. Whether some of these instructions will apply will depend upon what you find to be the facts. The facts that I have instructed you on various subjects in this case, including that of damages, must not be taken as indicating an opinion of the court as to what you should find to be the facts or as to which party is entitled to your verdict. Instruction number 19. You're admonished that no juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the trial, after the jury has retired, that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me in the absence of the other jurors. This means that if you learn during the course of the trial that you were acquainted with the facts of this case or the witnesses, and you have not previously told me of this relationship, you must then declare that fact to me. You communicate to the court through the bailiff marshal. During the course of this trial, the attorneys for both sides and court personnel, other than the bailiff marshal, are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk to you. To do so might contaminate your verdict. You're admonished additionally that you're not to visit the scene of any of the acts or occurrences made mention of during this trial unless specifically directed to do so by the court. Do not undertake any investigation of the case on your own or endeavor to research legal or factual issues on your own. Instruction number 19. The masculine form of these instructions, if applicable as shown by the text of the instructions and the evidence, applies to a female person. Instruction number 21. If during your deliberations you should desire to be further informed on any point of law or hear again portions of the testimony, you must reduce your request to a writing signed by the foreperson. The officer will then return the officer will then return you to the court where the information sought will be given to you in the presence of the parties and their attorneys. Remember, the court is not at liberty to supplement the evidence. Instruction number 22. Before trial, each party has a right to ask the other parties to answer written questions. These questions are called interrogatories. The answers to the interrogatories are also in writing and are sworn under oath. You must consider the questions and answers that were read to you the same as if questions and answers had been given in court. Instruction number 23, the lawyers and or witnesses have shown you charts and summaries to help explain the facts and may show you more in closing argument. The charts and summaries themselves, however, are not evidence or proof of any fact. Charts and summaries are only as good as the underlying evidence that supports them. You should therefore give them only such weight as you think the underlying evidence deserves. Instruction number 24, the fact that a witness has been convicted of a felony, if such be a fact, may be considered by you for the purpose of determining the credibility of that witness. The fact of such a conviction does not necessarily destroy or impair the witness's credibility. It is simply one of the circumstances that you may take into consideration in weighing the credibility of a witness's testimony. Instruction number 25, plaintiff seeks to establish a claim of negligence against defendant Zaon Collins. Plaintiff seeks to establish a claim under NRS 41.440 against defendant Marvin Collins. I will now instruct on the law relating to these claims. Instruction number 26. Generally, everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm to others. Negligence is a failure to exercise that degree of care which an ordinarily careful and prudent person would exercise under the same or similar circumstances. Ordinary care is that which persons of ordinary prudence exercise in the management of their own affairs in order to avoid injury to themselves or to others. You will note that the person whose conduct we set up as a standard is not the extraordinarily cautious individual, not the exceptionally skillful one, but a person of reasonable and ordinary prudence. While exceptional skill is to be admired and encouraged, the law does not demand it as a general standard of conduct. Instruction number 27. There is in force a statute, NRS 41.440, which reads as follows. Any liability imposed upon a spouse, son, daughter, parent, brother, sister, or other immediate member of a family arising out of his or her driving and operating a motor vehicle with the permission, express or implied, of such owner is hereby imposed upon the owner of the motor vehicle, and such owner shall be jointly and severally liable with his or her spouse, son, daughter, parent, brother, sister, or other immediate family member of a family for any damages resulting from such negligence or willful misconduct, and such negligent or willful misconduct shall be imputed to the owner of the motor vehicle for all purposes of civil damages. The court has ruled that this law applies to this case. This means that Marvin Collins will be held liable for any damages legally resulting from Zaon Collins's negligence. Instruction number 28. Plaintiff is seeking damages based upon claims of negligence and negligence per se against defendant Zaon Collins. Plaintiff has a burden of proving by a preponderance of the evidence all the facts necessary to establish: 1, that defendant Zaon Collins was negligent; 2, that plaintiff sustained damages; and 3, that such negligence was a legal cause of the damage sustained by plaintiff. Defendants are claiming plaintiff was comparatively negligent. Defendants have the burden of proving by a preponderance of the evidence all the facts necessary to establish: 1, the decedent Eric Echevarria was negligent; 2, that his negligence was a legal cause of his death. A preponderance of evidence means such evidence as, when considered and weighed against that opposed to it, has more convincing force and produces in your mind a belief that what is sought to be proved is more probably true than not true. In determining whether a party has met this burden, you will consider all the evidence, whether introduced by the plaintiff or defendant. Instruction 29. A legal cause of injury, damage, loss, or harm is a cause that is a substantial factor in bringing about the injury, damage, loss, or harm. A substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. Instruction 30. The preponderance or weight of the evidence does not necessarily increase with a greater number of witnesses. The testimony of one witness worthy of belief is sufficient for the proof of any fact and would justify a verdict in accordance with such testimony, even if a number of witnesses have testified to the contrary. If from the whole case, considering the credibility of the witnesses, and after weighing the various factors of evidence, you believe that there is a balance of probability pointing to the accuracy and honesty of the one witness, you should accept his or her testimony. Instruction 31. The defendant claims that the negligence of plaintiff's decedent contributed to his own death. To succeed on this claim, defendant must prove both of the following: that plaintiff's decedent was negligent, and that the negligence of plaintiff's decedent was the legal cause of his own death. A plaintiff may or may not recover damages if the negligence of plaintiff's decedent contributed more to his death than the negligence of the defendant. However, if plaintiff's decedent was negligent, the plaintiff may still recover a reduced sum so long as the comparative negligence of the plaintiff's decedent was not greater than that than the negligence of the defendant. You must determine that the plaintiff is entitled to recover upon the theories of negligence. If you determine that the plaintiff is entitled to recover upon the theory of negligence, you shall return by general verdict the total amount of damages sustained by the plaintiff, and you shall return a special verdict indicating the percentage of negligence attributable to plaintiff's decedent and to the defendant. The percentage of negligence attributable to plaintiff's decedent shall reduce the amount of such recovery by the proportionate amount of such negligence, and the reduction will be made by the court. Instruction number 32. Every person has the right to expect that every other person will use reasonable care and will not violate the law unless he or she knows or should know that the other person will not use reasonable care or will violate the law. Instruction 33. As used in these instructions, highway means the entire width between the boundary lines of every way dedicated to a public authority when any part of the way is open to the use of the public for purposes of vehicular traffic, whether or not the public authority is maintaining the way. Instruction 34. There was in force at the time of occurrence in question a law which reads as follows. It is unlawful for a person to drive or operate a vehicle of any kind or character at a rate of speed greater than is reasonable or proper, having due regard for the traffic, surface and width of the highway, the weather and other highway conditions. B, such a rate of speed as to endanger the life, limb, or property of another person. C, a rate of speed greater than that posted by a public authority for the particular portion of highway being traversed. D, a rate of speed that results in the injury of another person or any property. E, in any event, a rate of speed greater than 80 miles per hour. A violation of the law just read to you constitutes negligence as a matter of law. If you find that a party violated a law just read to you, it is your duty to find such violation to be negligence, and you should then consider the issue of whether that negligence was a legal cause of injury or damage to the plaintiff. Instruction 35. Defendant Zaon Collins pled guilty to the following charges arising from the subject collision. Count 1, reckless driving. Count 2, vehicular manslaughter. Reckless driving is defined as, it is unlawful for a person to drive a vehicle in willful or wanton disregard of the safety of persons or property on a highway or premises to which public has access. Vehicular manslaughter is defined as a person who, while driving or in actual physical control of any vehicle on any highway or premises to which the public has access, causes the death of another person through an act or omission that constitutes simple negligence, is guilty of vehicular manslaughter and shall be punished for a misdemeanor. Under Nevada law, this is conclusive evidence of all facts necessary to impose civil liability for the injury. Instruction number 36. There was in force at the time of occurrence in question a law which reads as follows. The driver of a vehicle within an intersection intending to turn to the left shall yield the right of way to any vehicle approaching from the opposite direction which is within the intersection or so close thereto as to constitute an immediate hazard. But such driver, having so yielded and having given a signal when and as required, may make such left turn, and the drivers of all other vehicles approaching the intersection from the opposite direction shall yield the right of way to the vehicle making the left turn. A violation of the law just read to you constitutes negligence as a matter of law. If you find that a party violated a law just read to you, it is your duty to find such violation to be negligence, and you should then consider the issue of whether that negligence was a legal cause of injury or damage to the plaintiff. Instruction 37. There was a law in force at the time of the occurrence in question, which reads as follows. It is unlawful for a person to drive or to be in actual physical control of a vehicle on a highway or on a premises to which the public has access with an amount of any of the following prohibited substances in his or her blood that is equal to or greater than prohibited substance, and then the blood nanograms per millimeter. A, marijuana, delta 9, tetrahydrocannabinol. 2, B, marijuana metabolite, 11-OH tetrahydrocannabinol. 5. If you find that plaintiff is entitled to compensatory damages for actual harm caused by defendant Zaon Collins's breach of obligation, you may consider whether you should award punitive damages against defendant Zaon Collins if the plaintiff proves 1. Defendant Zaon Collins willfully consumed or used a controlled substance such as marijuana, knowing that he would thereafter operate a motor vehicle. And 2, defendant Zaon Collins thereafter caused actual harm to the plaintiff by operating a motor vehicle in violation of NRS 484C 110. The purpose of punitive damages is to punish a wrongdoer that hereby harms the plaintiff and deter similar conduct from others in the community in the future, not to make the plaintiffs whole for their injuries. Consequently, a plaintiff is never entitled to punitive damages as a matter of right, and whether to award punitive damages against the defendant is entirely within your discretion. Instruction number 38. Clear and convincing evidence is that measure of degree of proof which will produce in your mind a firm belief or conviction as to the allegations sought to be established. It is an intermediate degree of proof, being more than a mere preponderance, but not to the extent of such certainty as is required to prove an issue beyond a reasonable doubt. Proof by clear and convincing evidence is proof by which persuades you that the truth of the contentions is highly likely. The only thing that needs to be proven by the plaintiff to the clear and convincing standard in this case is the punitive damages aspect of the case. Instruction number 39. Plaintiff Anna Marie Echevarria and Eric Echevarria Jr. are the heirs of the decedent, Eric Echevarria Sr. In determining the amount of losses, if any, suffered by the heirs as a legal result of the death of Eric Echevarria Sr., you will decide upon a sum of money sufficient to reasonably compensate each heir for the following items. 1. Each heir's loss of probable support, companionship, society, comfort, and consortium. In determining that loss, you may consider the financial support, if any, which the heir would have received from the decedent except for his death, and the right to receive support, if any, which the heir has lost by reason of his death. The right to receive support from another is not destroyed by the fact that the former does not need the support, nor by the fact that the latter has not provided it. You may also consider A, the age of the deceased and of the heirs, B, the health of the deceased and of the heirs, C, the respective life expectancies of the deceased and of the heirs, D, whether the deceased was kindly, affectionate, or otherwise, E, the disposition of the deceased to contribute financially to support their heirs, F, the earning capacity of the deceased, G, his habits of industry and thrift, and H, any other facts shown by the evidence indicating what benefits the heirs might reasonably have been expected to receive from the decedent had he lived. 2. Any damages for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent. 3. Any grief or sorrow suffered by the heirs. Instruction number 40. Plaintiff Anne Marie Echevarria is a personal representative of the estate of Eric Echevarria. Damages recoverable by the personal representative of the decedent on behalf of the estate include 1. Any special damages such as medical expenses, which the decedent incurred or sustained before his death, funeral expenses, burial expenses. And 2, any penalties, including but not limited to exemplary punitive damages that the decedent would have recovered if he had lived. Instruction number 41. You're not to discuss or even consider whether or not the plaintiff was carrying insurance to cover medical bills or any other damages he claims to have sustained. You're not to discuss or even consider whether or not the defendants were carrying insurance that would have reimbursed them for whatever sum of money that may be called upon to pay the plaintiff. Whether or not either party had insurance is immaterial and should make no difference in any verdict you may render in this case. Whether or not the verdict you render is collectible or the source or from whom the verdict may be collected also is immaterial and should make no difference in any verdict you may render in this case. Instruction number 42. If the jury determines the plaintiff is entitled to recover, it shall return by general verdict the total amount of damages the plaintiff would be entitled to recover from this accident. Thus, you are not to consider the negligence and or fault of any person who has not been made a party to this case. Instruction number 43. Throughout the course of this trial, it may have been necessary for the parties or their counsel to step away. They were not doing so to be disrespectful to you. Everyone did their absolute best to present for each stage of this trial. However, that was not always possible. I instruct you that you are not to hold a party or their attorney's absence from trial against either side. Jury instruction 44. It is your duty as jurors to consult with one another and to deliberate with a view toward reaching agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but should do so only after consideration of the case with your fellow jurors, and you should not hesitate to change an opinion when convinced that is erroneous. However, you should not be influenced to vote in any way on any question submitted to you by the single fact that a majority of the jurors or any of them favor such a decision. In other words, you should not surrender your honest convictions concerning the effect or weight of the evidence for the mere purpose of returning a verdict or solely because of the opinions of the other jurors. Whatever your verdict is, it must be the product of a careful and impartial consideration of all the evidence in this case under the rules of law as given to you by the court. Instruction 45. When you retire to consider your verdict, you must select one of your number to act as a foreperson who will preside over your deliberations and will be your spokesperson here in court. During your deliberations, you will have all the exhibits which were admitted into evidence, these written instructions and forms of verdict, which have been prepared for your convenience. In a civil action, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon a verdict, you shall have it signed and dated by your foreperson and then return with it to this room. Instruction 46. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by law as given in these instructions, and return a verdict which, according to your reason and candid judgment, is just and proper. Okay, so that concludes the jury instructions. At this time, ladies and gentlemen, we normally move to closing arguments, but we expect the first closing argument to be about 2 hours long. So before we do that, we can take a break during the closing argument, but you also have the option if you would like to take a quick break now. Does anyone want a quick break now? Okay, otherwise I'll ask you about an hour into the argument if anybody needs a break at that time. And our plan, just so you know, is to do the first closing argument. We should have lunch waiting for you in the jury room back there. I'm going to ask you if 45 minutes is an okay amount of time for lunch, and that you'll have lunch and then you'll come back and you'll hear the rest of the closing arguments and rebuttal. Okay. So with that being said, counsel, are you ready to proceed?
Yes, Your Honor.
Okay. So counsel, go ahead.
Your Honor, can we pull out the TV? I'm sorry.
Yes.
Thank you, Your Honor.
Yes. While we're doing that, since that's going to be a minute anyway, I don't think we actually got on the record all the council's names this morning. So why don't we just have everybody just make sure their names are on the record.
Ramzy Ladah for plaintiff.
Joseph Chu for the plaintiff.
Stephanie Zinna for defendant Marvin Collins.
Brad Jones on behalf of Marvin Collins.
You teach. Do you want to put your? Okay. Okay, so counsel, if you're ready to proceed, go ahead. You have a microphone, right?
Thank you, Your Honor. Yes, I do.
Okay, great. I'll leave it kind of up to you at like the hour mark.
Sure.
When you think this might be appropriate time to take a break to offer it,
Thank
okay?
you, Your Honor. Appreciate it. Oh, there we go. Perfect. Thank you. Thank you. Appreciate it.
Okay, go ahead, thank you.
Thank you, Your Honor. May it please the court. Good morning, ladies and gentlemen of the jury. Talked to Anne Marie and Eric Jr. over the weekend. I asked them, what do you want me to say to the jury? What do you want me to focus on? And they told me they just want me to thank you. So from both Anne Marie, Eric Jr., thank you. Eric Jr. also wanted me to tell you he wanted to be here today, but he can't because he's in finals. So, and from us, their attorneys, we also want to thank you. Thank you for your time. Thank you for bearing with us through this process. Thank you for paying attention. Thank you for focusing. Most of all, thank you for caring. I don't believe in coincidences. I believe you were chosen for this trial, for this case, all of you. And we went through this process, jury selection process, where we asked you a bunch of questions. And that was a time when you could talk back to us and tell us your feelings and your opinions. And I realize now you can't talk back to us, not until after deliberations, but this is my opportunity to have a little bit of a conversation with you about the law, about the evidence, about everything you've heard in the case. And I know you've been reacting throughout the trial, reacting to certain witnesses' testimony, certain things you've seen. And you've been communicating a little bit through your questions also, the questions you've been asking to the witnesses, of course. And, you know, we all, as humans, we want to feel important. Everyone is important. We're important to different people. But as citizens of this country, when we vote in politics, we have a voice. We have a very important voice. But we're one of a large number of people. One of, you know, if we're voting for president, for example, we're one of a couple 100 million people voting. We have a voice, but it's a very small voice. When you're voting as members of a jury, you're one of only a few people, a handful of people on the jury. So you have a loud voice, very powerful voice. And through this jury selection process that you saw, you know, we can't put every member of the community in the jury box. We can't put the entire community in the jury box for every trial and have the whole community weigh in on things. So what we do instead is we pick specific members of the community to serve. Many people will call it as the voice of the community. You get to talk for the community. You get to weigh in on what you've heard, what you've seen in this trial. You get to look at the conduct that you've seen in this case. You can decide if you want to condone that conduct, if you want that conduct condoned in your community, or if you want to say, we're not going to stand for that conduct. When this type of conduct kills someone, we're going to make sure justice is done. You know, this process, this jury process, where we get a jury to weigh in on a dispute between members of the community, something that happens in the community. This process was so important to our founding fathers in this country that they put it in the 7th Amendment. The right to trial by jury. It says, the right of trial by jury shall be preserved. It's one of the reasons why founding fathers fought the Revolutionary War to escape the tyranny of the British Empire. It's one of the reasons why so many brave young men and women serve in our military to protect the democracy of this country. It's one of the fundamental aspects of our democracy, the right to trial by jury, where members of the community where the incident happened, in this case where the crash occurred, get to come in and decide, are we going to stand for this type of conduct? Are we going to make sure justice is done for the victims in this case? And there's something written on the south entrance of this courthouse. It's an important little saying. It says, the moment you have protected an individual, you have protected society. And this is something you heard in this trial. It's in tune with that saying.
As part of your research on this case, you conducted any research on the percentage of traffic crash fatalities that were caused by speeding across the country?
I did, yes.
What percentage?
Across the country. Across the country in the US, the number of fatalities in, or the number of instances where fatalities occur, what is the percentage of those that involve speeding? And it's 28%.
And compare that percentage to the traffic crashes in Nevada.
I did, yes.
What was the percentage of traffic crashes in Nevada that were fatalities that were from speeding?
Slightly higher, 29% of fatalities in Nevada involve speeding.
Did you compare that to Clark County?
I did.
What was the percentage in Clark County of traffic fatalities that were caused by driver speeding?
32%.
So that means Clark County has a higher percentage of traffic crashes, crash fatalities caused by speeding than the nation as a whole.
It does, yes.
Did you also look at the average number of deaths over that period per year as a result of drivers speeding on the roadways here in Clark County?
I did, there was a 5-year window that was provided by the National Highway Traffic Safety Administration. During that 5 years, there was an average of 70 speeding related fatalities in Clark County per year.
And why is that important? Well, we know speeding causes deaths in our community. It's a major problem. And in this case, right here, based on the evidence you heard, you get to make a statement about it. You get to say, our community isn't going to stand for this anymore. Everyone needs to know. Everyone needs to know in our community, in this courthouse, that when someone speeds on our roadways and kills someone else, that justice will be served, that this courthouse can deliver justice, a full plate of justice. What I mean by that, a full plate of justice, I mean, not just a little justice. We need to make sure your verdict, based on the evidence you heard, sends a message that life has real value in our community, that we are not going to stand for speeders who cause deaths in our community. And maintenance men have their tools, and jurors, when they're doing their duty, you as jurors doing your duty, important duty here, you have your tools as well. And your tools in this case are the law, the jury instructions that were read to you. And there was a lot of talk about what the law is, what does the law mean? And finally, at the end of the trial, you get to hear the law. So I'm going to go through the law a little bit and talk about the evidence. I'm just going to hit the highlights. I'm going to do. The first jury instruction I want to talk about, jury instruction number 17. It says, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Common sense. That word is important. You get to use your common sense when you evaluate everything in this case. So let's look at common sense. This is the crash. You saw these pictures. You've seen them numerous times by now, so I'm going to go through them quickly. Oh, thank you. What does common sense tell us based on this crash? Crashes like this don't happen unless someone is driving recklessly with complete disregard for the safety of the rest of the community on our roadways. That's what Mr. Collins did that day. Driving with complete disregard for the safety of others. The next thing in this instruction that's important. It says, you may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. Common experience. You get to use your common experience when you're evaluating everything in this case. Common experience. Everyone drives on our roadways, knows that when someone flies by them, either direction, going a reckless speed, we look at that car and we say, that driver's going to kill someone. If he doesn't slow down, he's going to kill someone. So we know, based on your common experience, based on what you saw, the pictures, how this crash happened, we know Mr. Collins is at fault for this, 100%. Oh, you also get to use your common experience in evaluating how this has affected the family, Anne Marie and Eric Jr. What consequences this has had on them, how this has rippled through their family and just destroyed it. How important Mr. Echevarria, who was the head of the family, was to their whole life, everything they do every single day. And through your verdict, you get to write in a number that recognizes how much this affected them. You get to make a statement based on the evidence that, look, life is valuable. Life is valuable to a wife. Life is valuable to a son. The last part of this instruction is important. It says a verdict may never be influenced by sympathy, prejudice, or public opinion. We talked about sympathy in the jury selection process. Talked about how we don't want you to let sympathy towards either side affect you in this case, affect the number you write in. And we talked about how Mr. Collins is an individual. He's not a corporation. And I was a little worried because it's easy to have sympathy for him and say, well, how can we write in a big number in our verdict if he's just an individual? But you're not supposed to have sympathy. You're supposed to evaluate everything objectively. And I know you're going to follow the law and follow your duty to make sure your sympathy towards the defense side doesn't affect the number you write in at the end of this case, if you have any. All right, so the next instruction number 13, says a witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his or her opinion as to any manner in which he or she is skilled. I'm not going to read the rest of it. I just want to get the gist of it. You heard from expert witnesses in this trial. Which side did you hear expert witnesses from? Well, you heard from Sam Terry. You heard from Dr. Raymond Kelly. You heard from Dr. Hirschfeld. And you heard from Eugenia Larmore, the economist. No expert witnesses from the defense side. And it's not that they didn't hire any. You heard they had an economist. They just didn't bring the economist to trial. So all the expert witness testimony in this trial, everything you heard from all of those witnesses, is completely unrefuted, unrebutted by the defense. They have no counter to it via their own expert witness. And they had the opportunity. They had the opportunity. If they didn't like what Sam Terry had to say, they could go get their own expert witness, say, oh, he's wrong. They didn't do it. They didn't like what Raymond Kelly had to say, they could get their own toxicologist to come in and say, oh, no, Raymond Kelly is wrong. They didn't do it. You get to evaluate that and say, unrefuted expert testimony. So throughout this process, this closing, I want to go over the verdict form, a little step by step, as kind of a guide to how we are requesting you fill it out. And the verdict form has two main sections. The first section on pages 1 and down to the middle of page 2 is liability. This is the first page. This is the second page. It goes all the way down about halfway for liability. And then the second section, I should say, is the damages section. It's on page 2, about halfway down, over into page 3. I'm going to go through that in detail. I'll split up between liability and damages. So I'm going to start off with liability, since that's where the verdict form starts off. This instruction tells you what claims we're making against each defendant. It says, plaintiff seeks to establish a claim of negligence against defendant Zaon Collins. Plaintiff seeks to establish a claim under NRS 41.440 against defendant Marvin Collins. I will now instruct you on the law relating to these claims. So the first thing I want to talk about is Marvin Collins. And the reason I want to talk about it now is because I'm not going to talk about him throughout the trial, because I don't need to. And this instruction tells you why. Now, there's been a lot of questions from Marvin about, did you own the vehicle? How often did you let Zaon drive? Was he a permissive driver? And finally, through all the questioning, we established this. And it says, any liability imposed upon a spouse, son, daughter, parent, brother, sister, or other immediate family member arising out of his or her driving and operating a motor vehicle with the permission, express or implied, of such owner is hereby imposed upon the owner of the motor vehicle. And such owner shall be jointly and severally liable with his or her spouse, son, daughter, parent, brother, sister, or other immediate family member for any damages resulting from such negligence or willful misconduct. Any and all of Zaon Collins' negligence, because of this law, if you find Zaon Collins negligent, and any damages you assess against him automatically get imputed to Marvin Collins. So at this point, I don't need to talk about the tickets or whether he knew about the tickets or anything else. It's already been established by the court. Whatever you assess against Zaon automatically goes also against Marvin, both of them. That's why I don't need to talk about Marvin anymore. It says this means Marvin Collins will be held liable for any damages legally resulting from Zaon Collins' negligence. That's as a matter of law, decided by the court. All right, so now I want to talk about what is negligence and what is not negligence. This describes negligence. It says generally, everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm to others. Negligence is the failure to exercise that degree of care which an ordinarily careful and prudent person would exercise under the same or similar circumstances. Ordinary care is that care which persons of ordinary prudence exercise in the management of their own affairs in order to avoid injury to themselves or to others. And this last paragraph is very important. It says, you will note that the person whose conduct we set up as a standard is not the extraordinarily cautious one, nor the exceptionally skilled one, but a person of reasonable and ordinary prudence. So, let's talk about negligence. What is negligence? Reasonable and ordinary prudence. Be a reasonable person. Follow the rules. Or at least be close to following the rules. Reasonable, for negligence, we don't need to prove that Zaon Collins intended to harm Mr. Echevarria. We never alleged that. We're not claiming that he wanted to hurt him that day. Even though his conduct is very reckless, we're not claiming that he wanted to hurt Mr. Echevarria. That's not a claim. We also are not claiming that he wanted to get in a crash that day. That's not a claim. That's not negligence. That would be intentional. Negligence is just not following the rules. And as a result of not following the rules, not being reasonable, you injure someone else. That's negligence. So during your deliberations, if someone in the back says, well, Mr. Collins wasn't trying to harm Mr. Echevarria, so we shouldn't assess a verdict against him. That's not what negligence is. Tell them negligence doesn't require an intent to harm. That's not what it's about. It's about just not following the rules. Or an easy way to explain it is a safety rule violation. You violate the rules of the road. If someone violates the rules of the road and injures someone else, then that's negligence. The purpose of these rules, like all the rules of the road, as we know, is to keep everyone safe. And that's why when people aren't following the rules and they injure someone else, we need to make sure that the rule violation has some teeth, that in court, it actually has some power, that it actually enforces the rule by awarding the right amount in a verdict, by making sure justice is done. That's the only way these rules have real meaning. All right, so now I want to talk about the burdens, the respective burdens. Now, we talked a lot about in criminal cases, a different burden than in a civil case and everything else. So finally, we get to explain what the burden is and who has what burden. Okay, so this says plaintiff is seeking damages based on claims of negligence and negligence per se against defendant Zaon Collins. Plaintiff has the burden of proving by a preponderance of the evidence all the facts necessary to establish, 1, the defendant Zaon Collins was negligent, 2, the plaintiff sustained damage, and 3, that such negligence was a legal cause of the damage sustained by the plaintiff. That is plaintiff's burden by a preponderance of the evidence. In a second, I'm going to talk about what a preponderance of the evidence means. But defendant has their own burden. They're trying to claim Mr. Echevarria, who is no longer here, who can't get on the stand to defend himself, can't get on the stand and explain what happened that day. They're claiming that he is at fault. And they have the burden to establish that. It says, defendants are claiming plaintiff was comparatively negligent. They're claiming he was also at fault. Defendants have the burden of proving by preponderance of the evidence that all the facts necessary to establish, 1, that the decedent, Eric Echevarria, was negligent, and that and two, that his negligence was a legal cause of his death. Okay. Well, first of all, the second part, that his negligence was a legal cause of death, of his death. We know nothing he did was the cause of his death because Mr. Collins' high rate of speed is what caused Mr. Echevarria's death. This crash at a high rate of speed is what caused these blunt force injuries to Mr. Echevarria. That's what caused him to pass away. So even if they try to say that Mr. Echevarria was partially negligent somehow, that didn't cause his death. The speed is what caused his death. It's a terrible crash at a high rate of speed. But the point is, they have the burden to establish that Mr. Echevarria was partially at fault. So what's the preponderance of the evidence? The respective burdens. We have the burden to prove he's at fault. He has the burden to try to prove Mr. Echevarria was at fault. And the burden is by a preponderance of the evidence. A preponderance of the evidence means such evidence as, when considered and weighed against that opposed to it, has more convincing force, produces in your mind a belief that what is sought to be proved is more probably true than not true. So you're weighing both sets of evidence on both sides. Which set of evidence wins? And it can be by just a little feather. So sometimes we talk about the scales of justice in terms of this standard, the preponderance of the evidence standard. Put the scales of justice up, put something over here, piece of evidence over here, piece of evidence over here, another piece of evidence over here, another one over here. Which side is more convincing? Which side, even if it just barely beats out the other side, even if we just barely beat out the other side, we win. Another way to look at it is when we're trying to establish that everything we need to establish under a preponderance of the evidence, we don't need to score a touchdown. All we have to do is get past the 50-yard line on each issue. But we think we got further and we scored a touchdown on each issue we presented. Everything that you, the jury, are evaluating in this case. Another way to look at that burden of proof for a preponderance of the evidence, I like to look at it as a glass of water. How full do we have to fill up that glass of water in order for you to be convinced under the standard and rule in favor of the plaintiff? All we have to do is fill it up past 50%. If it's just past 50%, at 50.001%, we win under the preponderance of the evidence standard. There can still be doubt in the cup. There can be a whole almost half a glass of doubt. But as long as we get past that halfway mark in the cup when we fill up our evidence, we've won. But we think we filled up the cup all the way. Full glass of water on every issue. And since we're talking about the liability part of this case, this is a good quote. I really like it. From Abraham Lincoln. It says, "You cannot escape the responsibility of tomorrow by evading it today." They've been trying to escape his responsibility for this crash since the very start, since the beginning. And you've seen that. So the first question you're going to be asked to answer in the verdict form. Do you find by preponderance of the evidence that Zaon Collins was negligent? Yes. It's easy on this one. He was negligent. Second question, do you find by preponderance of the evidence that Zaon Collins' negligence was a legal cause of Eric Echevarria Sr.'s death? Yes. His negligence caused Mr. Echevarria's death. We know the speed. We've gone over it numerous times. There's no dispute on this case as to his speed. Even they're admitting he was going so fast. But even Zaon admitted how fast he was going. And he admitted that high rate of speed like that is very dangerous. But he said he wasn't paying attention. Let's hear it.
All right, Zaon, the question is, going 88 and 35 dangerous.
Yeah, going 88 and 35 dangerous, people can get hurt.
Thank you. What are the reasons why going 88 and 35 are dangerous?
People can get hurt. And, you know, it's not what you do, it's not what you're supposed to do.
And then he was asked this question from his own attorney about whether he knew the speed limit that day. This is his answer.
Zaon,
What happened?
Zaon, did you understand that the speed limit on that road was 35?
Yeah, but I really wasn't paying attention.
It's amazing to see how, as we go through these instructions, the law on negligence and damages, how it empowers a jury, empowers you to make sure the injured victim here is compensated for. The injured victim gets justice through a case like this. So this is an important instruction. And the reason it's important because a lot of the rules of the road, a lot of the laws that we're going to be talking about use the word highway. And the word highway is not what our colloquial understanding of it. When it's used in the laws, it means just any street. It says, as used in these instructions, highway means the entire width between the boundary lines of every way dedicated to a public authority when any part of the way is open to the use of the public for purposes of vehicular traffic, whether or not the public authority is maintaining the way. So a highway is any street, Durango, Tropicana, Sahara, Charleston, any street you can think of on our roadways. Those are all, they qualify as highways under the law. Doesn't have to be the 95 or the 15. Those are not highways. Those technically are freeways. So every street, including Fort Apache, that Mr. Collins was driving on was a highway. I mentioned that because I want to look at now what he pled guilty to. This instruction says, defendant Zaon Collins pled guilty to the following charges arising from the subject collision. Count 1, reckless driving. Count 2, vehicular manslaughter. What is reckless driving and what is vehicular manslaughter? Well, here's the guilty plea agreement. And here's the judgment of conviction. So what did he plead guilty to? Well, reckless driving, it says it is unlawful for a person to drive a vehicle in willful or wanton disregard of the safety of persons or property on a highway or premises to which the public has access. Willful or wanton disregard of the safety of persons. He disregarded the safety of the public. And he pled guilty to that. But even more importantly is the second one. Vehicular manslaughter. It's defined as a person who, while driving or in actual physical control of any vehicle on a highway or premises to which the public has access, causes the death of another person through an act or omission that constitutes simple negligence. It keeps claiming that he wasn't the cause, or he wasn't fully the cause of this crash, or he wasn't fully the cause of Mr. Echevarria's death, but he pled guilty to something that actually says his actions caused Mr. Echevarria's death. That's why it says, causes the death of another person. His act, through this plea of guilt, he admitted that his act caused Mr. Echevarria's death. Not that it was a partial cause or that it was one of the causes. It says causes the death. And then the last part of this instruction is important. It says, under Nevada law, this is conclusive evidence of all facts necessary to impose civil liability for the injury. Conclusive. The truth is, with this instruction, you don't have to look any further. You can use the common meaning of the word conclusive. I mean, it's done. Liability's over. He's at fault 100% for this crash. because he pled guilty to it. But they still want to try to argue he's not fully at fault. That's what they've been doing from the start. So I want to keep going with these rules. This is the next one, the speeding one. And what you'll see is that he violated every single provision of this one, A through E. It says, there was enforced at the time of the occurrence in question a law which read as follows. It is unlawful for any person to drive or operate a vehicle of any kind or character at a rate of speed greater than is reasonable or proper, having due regard for the traffic, surf, and width of the highways, the weather, and other highway conditions. Well, you can decide, is driving 88 and a 35, is that greater than is reasonable or proper? I would say so. The good news is you get to decide. You're empowered to decide. You're the jury. B, such a rate of speed as to endanger the life, limb, or property of any person. Did he drive at a rate of speed that endangered the life, liberty, or property of another person? Absolutely. He killed someone. C, a rate of speed greater than that posted by a public authority for that particular portion of highway being traversed. We know the speed limit there was 35. He's violating the posted speed limit. D, a rate of speed that results in the injury of another person or another property. We know he injured someone. He killed someone. He violated this provision as well. And then E, in any event, a rate of speed greater than 80 miles per hour. So even if there's a brand new road out in the middle of nowhere, it's just been paved, and it doesn't have a posted speed limit, and no one drives on that road, even if Zaon was driving on that hypothetical road out in the middle of nowhere, he still would not be allowed to drive over 80 miles an hour. He violated every single provision of this one. It says a violation of the law just read to you constitutes negligence as a matter of law. So what did they do about his speed? And this is from his deposition. And from the start, they've been trying to say, well, everyone speeds on the road. It's okay that he was speeding. Everyone else speeds on that road. Let's hear it.
When the collision occurred, how fast were you going?
I don't know. Over the speed limit, but I don't know how fast I was going.
You said over the speed limit?
Yeah.
How much over the speed limit?
I don't remember.
How do you know you were going over the speed limit if you don't remember how fast you were going?
Because that everyone goes over the speed limit on that road.
So the way you know you were going over the speed limit when the collision occurred is because everyone goes over the speed limit on that road. Is that correct?
Yes, I believe so, yes.
But we had a great answer from Robin Lee, who drives on that road regularly. Sorry. Here it is.
Yeah, I've seen it, been there very long.
Yes, I lived there a few years.
You made that left turn from Fort Apache to Furnace Call many times.
Every time I went home.
In your experience, do people often speed on the road in Fort Apache?
Not 90 miles an hour.
So even in trial, they were trying to say that. Everyone speeds on the road. In your experience, doesn't everyone speed on the road? It's not an excuse.
If it was going 35 miles an hour, instead of the speed he was going, from 2 minus 5 to 2.5 seconds, all the way up to reaching the intersection. By the time he reaches the intersection, where would the Echevarria vehicle have been?
So if we move Mr. Collins' vehicle forward from this position at 35 miles per hour
Yes.
versus the faster rate of speed he was actually traveling through that, he would arrive at this what we call conflict point, 2.9 seconds later, and at that time, Mr. Echevarria would be approximately 80 feet down Furnace Gulch.
If he was going the speed limit, Mr. Echevarria would have had an extra 2.9 seconds more than he had. He would have been all the way down Furnace Gulch to his house by the time Mr. Collins reached the intersection. If he's going the speed limit, this crash never occurs. But then we also asked Mr. Terry to do the calculations based on assuming Mr. Collins was going 45 from T minus 2.5 seconds up to the point of impact. And this is what he said. We got a couple different views from the cameras. There's one right there, just so you know, and there's one over there from the news that's been here. So there's a couple different perspectives of videos that I've been playing based on which one has better audio or better visibility.
2.5 seconds onward, if Mr. Collins was going 45 miles an hour, still 10 miles an hour over the speed limit, that Mr. Echevarria would have still been well onto the Furnace Gulch by the time Mr. Collins made it to the intersection. That's correct. And how far down would the event onto the Furnace Gulch would the event?
It's like 47 feet south. It's right over the edge, 47 feet.
He would have been 40, even if he was going 45, 10 miles over the speed limit. Mr. Echevarria would have finished his turn and been 47 feet down onto Furnace Gulch by the time Mr. Collins just made it to the intersection. This is how we know his high rate of speed is both the cause of the crash and the cause of Mr. Echevarria's death. So this is the law the defense is going to focus on. And it doesn't say what they want it to say. Here it is. It says there was enforced at the time of the occurrence in question a law which read as follows. The driver of a vehicle within an intersection intending to turn to the left shall yield the right of way to any vehicle approaching from the opposite direction, which is within the intersection or so close thereto as to constitute an immediate hazard. So you don't have to yield to all cars if you're turning left across traffic. What you have to yield to is any other cars coming from the opposite direction that are either in the intersection or that are so close to the intersection that they constitute an immediate hazard. That's what the law says. And it goes on and says, but such driver, having so yielded. Oh, sorry. So this is the 2.5 seconds before impact. We know how far away he was at that point. Mr. Collins is 275.6 feet away, almost a full football field away. When Mr. Echevarria is in the intersection making his turn, almost a full football field away. He's not in the intersection, we know that, because he's 275.6 feet away from the intersection. And he's not an immediate hazard under normal conditions if he's following the law, because he's way too far away to get there if he's just going a reasonable speed, even if he's going over the speed limit by 10 miles an hour, 15 miles an hour. So he's not an immediate hazard. So technically, when you read that law, Mr. Echevarria didn't have to yield to him. But you'll see, and this is where I get the number from. This is from Sam Terry's black box data. 275.6 feet away at negative 2.5 seconds. What you'll see is when we keep reading this law, it shows that Mr. Echevarria actually had the right of way because Mr. Collins was so far away. It says, but such driver, having so yielded and having given a signal, and Robin Lee said he used the signal, when and as required, may make such left turn, and the drivers of all other vehicles approaching the intersection from the opposite direction shall yield the right of way to the vehicle making the left turn. The point is, if you're going a crazy rate of speed down the street and someone turns left, you can't just run into them. You can't just say, get out of my way. I'm going to slam into you and you're going to be at fault, even though I'm going a crazy speed. It's not the way the law works. That's the way they want it to work. It doesn't work that way. Actually says the opposite. If he's far enough away that he's not an immediate hazard and he's not in the intersection, once Mr. Echevarria starts his turn, Mr. Collins has to yield to him. That's why the second part of this statute, second part of this law is so important. It's where it says all other vehicles approaching the intersection from the opposite direction shall yield the right of way to the vehicle making the left turn. All right, so I want to talk about Sam Terry's testimony about this a little bit. And this instruction touches on Sam Terry's opinions on this. It says an expert witness has testified about her reliance upon books, treatises, articles, and statements that have not been admitted into evidence. Well, Mr. Terry talked a little bit about these traffic accident studies or these traffic studies where they have cameras at intersections. They look at under what situations most people will turn left. What space, what distance from the intersection most people will say, it's enough space. I have enough space. It's time for me to turn left. The coast is clear. And here's Mr. Terry saying, because Mr. Collins is so far away, he was not an immediate hazard under the law. So he does not require, Mr. Echevarria is not required to yield to Mr. Collins if he's not an immediate hazard. Here it is.
From Mr. Echevarria's perspective, would he been able to tell that a Dodge Challenger was an immediate hazard to him when he made the decision to make that left turn?
No.
Is it because of the Challenger high rate of speed?
Correct.
Are there studies that give us good estimates on what percentage of the motoring public would make a left turn in that situation based on the gap distance that Mr. Echevarria perceived he had?
Yes, there are studies.
What percentage?
80 to 82% of all the motorists would accept a 5.4 second gap or 5.5 second gap that Mr. Echevarria perceived that he had.
Where do those studies come from?
There's a number of them, and most of them are actual real world naturalistic studies. They're actually videos of intersections with left turning vehicles with marked known distances, and people compile that data for where the approaching vehicle is with respect to the onset of the turning vehicle that was going to turn across the path.
Does that mean, based on those studies and that data, that 80% of the motoring public would have attempted the same turn that Mr. Echevarria did in that situation?
Correct, that's exactly what it means.
That means 80 to 82% of people would have attempted that turn based on those studies, based on the space he had. And he would not have been able to tell how fast Mr. Collins is going. You already explained that earlier. I'm sure you remember that. But the point is, well, someone on the defense may say, well, it's not 100%, not 100% of people would make that left turn. It's only 80 to 82%. Well, remember the law says Mr. Echevarria doesn't need to be extraordinarily careful. He just needs to be the reasonable and prudent person in order to be not negligent. He was being reasonable and prudent. If 80 to 82% of people would make that same turn, then that's reasonable and prudent. He's well within the percentage that we would qualify as reasonable and prudent. And then in addition to these studies, these real life studies, we have an actual person who was actually at the scene, who actually witnessed the crash and was actually about to turn left also, and actually saw what happened. And she said herself, she would have made that left turn in the same actual situation. And you heard her testify. Highly credible. Talked about how safe of a driver she was. Here it is.
When you personally observe as the started to make its left turn,
Yes,
were you surprised to see the white Hyundai start to make its left turn at the time?
no,
Can you tell us why not?
because it was time to go left. It looked to me to be safe to go left at that moment.
Sorry, can you speak up a little bit? I apologize.
It looked to me to be safe to make a left at that moment, so, I was not surprised.
What about your perception, your observations at the time gave you the impression it was safe?
The coast looked clear to me.
Coast look clear. So we have actual studies of other people on the roadways that said 80 to 82% of people would have turned left. And then we have a real person who was there right behind Mr. Echevarria who said, if I was in Mr. Echevarria's shoes, I would have attempted that same turn at the same time he did. Here she said it again.
You said you would have made that left.
From what it looked like to me, the coast was clear and I would have made that left.
If you were in the position of the white line that you were first in line at that intersection, you would have made the same left turn.
Yes, I would have.
At the same time that I made it.
Yes, I'm saying that.
Then you probably recall at another point she talked about how Mr. Collins came out of nowhere like a meteor because he was going so fast. You can't judge his speed and he's far away and you make the turn and he just appears out of nowhere, bam! Because anyone who's made a left turn and someone's going really fast at you, you don't realize how fast they're going until the last second, right before they hit you. Like, oh my God, he was going way too fast. And you just make it through the intersection and they fly by. Oh my God, I couldn't tell he was going so fast because they're far away. So then, we've got some testimony from Zaon.
Your testimony, tell me if I'm wrong, your testimony is Mr. Echevarria stopped in the middle of the intersection.
Yeah, he was right. He was in the other lane. He stopped right like that. Yeah.
In the intersection.
Yes.
Thank you.
So now we got this claim that Mr. Echevarria somehow stopped in the middle of the intersection. Well, we know that claim is false. We know it because the actual black box data. What does the black box data show? It shows the vehicle speed, and it shows from actually all the way through, he never stopped. But if we just focus from T minus, let's say 2.5 up to the moment of impact, he's continuously going a reasonable speed, 6 miles an hour, 9 miles an hour, onward. And Sam Terry testified that. He refuted this idea that Mr. Echevarria stopped.
So moving continuously the entire time of the turning process,
Yes,
is that from T minus 4.5 all the way to the point of impact?
that's correct.
Okay, thank you. Does the Echevarria vehicle slow down or speed up over the period of time between T minus 4.5 up to the point of impact?
It continues to increase in speed through the entire last 5 seconds.
Was he in the continuous process of making a turn throughout that period?
Yes,
Did he stop at any point during his turn?
no, sir.
Was he driving at a reasonable speed for a turn based on your reviewing the data?
Yes,
Anything abnormal about his turn?
not that I can see, no.
Normal, regular turn. Nothing abnormal. No stops. Just making a turn. With a vehicle coming at him from a far ways away that's driving at a reckless rate of speed. It hits him like a meteor out of nowhere. So then we have this video. And Sam Terry fortunately explained this video because defense focused in on the top part of this video to make it look like Mr. Echevarria turned right in front of Zaon. Like the turn was right out in front of him. But he explained why this video is misleading. This is it right here.
Same distance, so again, it's kind of go by here, laterally going past, so as they get further out, in the video, they're going away from this. Again, difficult to judge time, speed, distance, and what's the
So they focus in on video with a depth perception that's misleading to try to make it look like Mr. Echevarria pulled out right in front of Mr. Collins. But there's a big problem with their argument. One, the video is misleading, but two, we have actual evidence on the ground that Mr. Echevarria was almost through the turn, almost all the way through the intersection when the crash happened. We have that from where the AIC is. First of all, we can see that yellow line there, that's the bike lane. Here you can see the AIC where the crash occurred. He's almost all the way through the intersection, almost on the little, he's actually in the bike lane. You can see it right there. There it is. And there's the AIC again. He almost made it all the way through the intersection, meaning he had the right of way, meaning he didn't turn right in front of him. Because if he turned right in front of him, the crash would have occurred on the other side. And you can see from this perspective how big that intersection is. It's not a tiny intersection. It's a big intersection, this side of the street. See where the turn lane is? All the way up here. This is the turn lane right here. So he would have come across all this, all the way, almost made it through, which means he didn't swerve. Sorry, he didn't pull out in front of Mr. Collins. All right, so the next instruction. This one says, every person has the right to expect that every other person will use reasonable care and will not violate the law. We all have a right when we're driving to expect others to follow the law, to be reasonable. We don't have to expect them to be driving at 88 miles an hour. And Mr. Collins admitted this.
You agree that when someone's driving and gonna turn left, cut across traffic, they have a reasonable expectation that the cross traffic, which is you, are going to be following the speed limit and not driving above the speed limit.
Yes,
You agree?
I agree.
Okay. So it was reasonable for him to expect that you would be following the speed limit.
Yeah.
Good. Thank you. If you are not going the speed limit, you are going to get to the intersection faster. You agree? Okay. If you're going slower, you're gonna get to a location slower. If you're going faster, you're going to get to a location faster on the road. You understand that, right?
Yeah, I understand that.
Okay. So if you were going the speed limit, you would have had more time to get through the intersection and finish the left turn. You understand that, correct?
I understand that.
Okay. So if you were going the speed limit, he likely would have made it through his turn and the collision never would have occurred. You understand that, correct?
I understand that.
So then we have their criminal defense attorney, who apparently said to the news that Mr. Echevarria was on some drugs.
Objection, Your Honor. This isn't in evidence.
It's unobjected to testimony at trial, Your Honor.
And counsel part, please.